I just wanted to finish up the First Amendment and then talk about the Second Amendment today. So we've already talked about the two religious clauses, the Establishment Clause and the Free Exercise Clause. Moreover, we've talked about freedom of speech, and that then leaves the freedom of the press and the freedom of assembly and the freedom of petition. So there's not a lot to add to freedom of the press than we've already talked about through freedom of the speech. Neer versus Minnesota, which is 6 years after Gitlow versus New York incorporated freedom of the press. So it's actually the second incorporation case. Again, there's that New York Times versus US case that struck down the government's attempt to censor the New York Times, again, creating that doctrine of the freedom from prior restraint. Laws or rulings regarding libel are similar to that of slander. So again, you can remember New York Times versus Sullivan. But then just like speech entails more than actual speech. So for example, symbolic speech, the press involves more than actual press. So for example, radio and television, essentially in this more modern era, the freedom of speech, freedom of press tend to have been, combined. There are some nuanced differences, for example, like when it comes to television and radio, and that is because those are broadcast over public airwaves, and therefore they are leased from the government, and therefore they can be regulated more than, let's say, other means. Like, a book that is printed uses private means and therefore is less regulated. The internet actually uses private means. We typically use private companies to access the internet, and therefore there's a lot less regulation that goes on in that. But the FCC, the Federal Communications Commission, is in charge of regulating publicly leased airwaves, and it's why they can fine companies that violate their rules, and so there's greater regulation, greater restrictions as the First Amendment intersects their medium than in perhaps others. Freedom of assembly. First of all, you should know that freedom of assembly is a freedom to assemble on public property and public property only. So you don't have a freedom to assemble on private property. And you should also know that the government can place restrictions on the freedom of assembly. They can be time restrictions, manner restrictions, place restrictions. So these time, manner, and place restrictions can be put in place by the government as long as the government demonstrates three key criteria. Can you guess what they are? I'm going to assume you got it right, and that is if the government demonstrates, number one, a compelling interest, if it's neutral, and it's done in the least restrictive means. So realize that the compelling interest is different on the situation. So for example, like, hypothetical situation is, should you disagree with the government's, response to COVID-19 and you wanted to protest, and you decide to put together 1,000-person protest, out on the streets in violation of, stay-at-home orders, and the government decides to then arrest you and to prosecute you for violating that law. Well, does your freedom of assembly allow you to defy that government order? Is that government order unconstitutional? And so, once again, we would have to ask, all right, they're putting greater time, manner, and place restrictions on the freedom to assembly than they usually do. And so the question then becomes, can the government do this? Do they have a compelling interest? Again, is it neutral? Like, is it applied, to everyone, or do we target specific groups? And are the place restrictions in which you can assemble, again, do they have that compelling interest, neutrality, and are they done in the least kind of restrictive means in order to accomplish that compelling interest? And so again, our current government response to COVID-19 raises some interesting kind of, issues as it intersects, with the First Amendment. The freedom to petition is pretty boring. You have a freedom to petition. That doesn't mean the government actually is going to respond in the way that you like to. And there's not a lot of case history on the freedom to petition because, if anything, our government has made it easier to petition the government over the years than tried to restrict it. And then not mentioned in the First Amendment is this idea of association. And so this is one of those implied rights of the First Amendment. Do you have the ability to associate yourself with groups that you want to? Is there a freedom of association? So if you have freedom of speech and the free exercise of religion and the free assembly, well, do you not then have a freedom to, to join and to associate yourself with different groups? The question also then is the other way. Do those groups have a freedom of association as well? And so Supreme Court has ruled that associations no longer can be required to disclose their membership. So for example, like, during the Cold War and the Red Scare, there were laws that were imposed upon communist organizations that were not necessarily imposed on other organizations. And that has fallen by the wayside given the current court's interpretation on, again, compelling interest, neutrality, and least restrictive means. No longer can the government require loyalty oaths to the government to join, certain associations or to join certain areas of employment. It used to be for teachers. Teachers had to swear like loyalty oaths to the government and the Constitution. And then in a key case in terms of freedom of association was one of that of the Boy Scouts. And this again comes up with the question of, can groups choose not to associate with you? And so when the Boy Scouts decided to kick out one of their leaders who came out as gay, do the Boy Scouts have the ability to do that? And the Supreme Court actually ruled in their favor. Now the Boy Scouts themselves as an organization have decided to not have that policy anymore. But the question then becomes, like, is it in their right to do so? Sexual orientation is not currently a protected class under federal law, in the same way that race or religion and sex are. And so therefore, if someone and their association with you, can potentially violate the kind of mission of your organization, do groups have the ability to disassociate, with them? And so, this poses some really difficult, questions, particularly when it comes to religious organizations that are operating in the public sphere, particularly if they're taking and making use of, public facilities, like schools or universities. And so, this is something, especially as it intersects with issues related to like sexual orientation and gender identity, are certainly not been, fully answered, at this point, and are just going to, continue to be issues on kind of the forefront of our public discourse. And then we get to the Second Amendment. If you're a Adam Sandler fan, you might recognize that that slogan was on a shirt of the bad guy in Happy Gilmore. That's the golfing one. He also played a villain in a James Bond movie as well. And so when we talk about the Second Amendment, most of you, when you hear the Second Amendment, you probably can recite the last part of the Second Amendment, which is the right to keep and bear arms. But my question is, do you know the whole Second Amendment? And then the question that follows after that is, well, do you know what that means? And so the Second Amendment, starts by saying a well-regulated militia being necessary for the security of a free people, the right to keep and bear arms, shall not be infringed. And so one of the questions is, well, first of all, what does it mean that a well-regulated militia? What is the definition of a well-regulated militia? What's the relationship between that militia and the second clause of the right to keep and bear arms? And so we're going to kind of be talking about, well, what does the Second Amendment actually mean? What's the controversy behind it, and where has the court arrived at this today? fundamentally, one of the early questions is, and the question still today is the Second Amendment a state right or is it an individual right? I mean, is the purpose of the Second Amendment to protect the states against that of the federal government? Or is it designed to protect individuals from the government? And if you go back to, the discourse at the time that the Second Amendment was being drafted and ratified, you're going to be disappointed because the founding fathers themselves disagreed. So there were those who were a part of the founding fathers who were horrified over Shays' Rebellion. And if you recall, like Shays' Rebellion was one of the key catalysts to get people, to Philadelphia in order to change the Articles of Confederation. And so there were those who, when that time for a Bill of Rights came up, there was a desire to make sure that the ghosts of Shays' Rebellion had been slain. That never again would a people be able to take up arms and essentially pose a threat enough to kind of overthrow the government. And particularly, they were very worried about their own state versus that of the federal government. And so, states should have the ability and protection to keep a militia in order to ensure, their rights against perhaps this kind of encroaching federal government. They were very worried, again, about this bigger government being able to take away their rights. And then there were people like Thomas Jefferson who, said that a little rebellion now and then is a good thing, and as necessary in the political world as storms in the physical world. Now, by the way, that Jefferson quote is a great way to keep in your arsenal, particularly if you ever get in a conflict, with your parents, which might be happening more and more often as you're all stuck together in quarantine. And so the next time there's a tension, you get in a fight or something like that, a conflict with your parents, just quote Thomas Jefferson, like, Mom, Dad, as Thomas Jefferson said, a little rebellion now and then is a good thing. Let me know how that goes. But when we talk, so there was disagreement over whether or not the Second Amendment was designed to be a state right or an individual right. And then some history is that, well, during the time of colonial America, what is clear is that almost every household had a gun. You had a gun either by necessity for survival. Oftentimes people survived by hunting food. Sometimes it was legally required in case the state wanted to actually call up a militia. But it's also clear that the level of those firearms and their ability to kind of inflict harm were different over time. And guns became increasingly more and more lethal. And then the question becomes, well, does that matter? Now, my guess is, no matter where you sit on the spectrum of the Second Amendment and its role, is that we can all agree that a Second Amendment means something, meaning that no matter how desirable it is for you to regulate, firearms, you need to agree that the Second Amendment was put into place in order to achieve certain protection. I mean, there's a purpose why we have the Second Amendment. Moreover, if you believe that the Second Amendment gives you, the individual, the greatest amount of freedom, well, you also have to agree that at some point there is a line. There is a line in which, the Second Amendment does not give you the ability to own any weapon of any magnitude that you desire. And so, no matter how liberal you are in your interpretation of this freedom, we could all find a way, we could all find an agreement that, for example, like the Second Amendment does not allow you to possess, a tactical nuke. So at some point there's a line, meaning the Second Amendment means something and it doesn't mean everything. And so then once we've come to that agreement, well, then we need to figure out, okay, well, then where's the line? And that's not easy. And so, but the general consensus over time is that the Second Amendment basically allowed the government, the federal government, part of that well-regulated militia, and by the way, regulated does not actually mean, police, it essentially means trained. But essentially, this idea, this interpretation, was over time historically that the federal government had the ability to regulate weapons that had a military application. So, for example, if it was military issue, they could regulate it. If it was not, they essentially could not. Well, the problem came in when suddenly, like over time, particularly that in the 1920s, remember you had Prohibition, you had the rise of Al Capone, and suddenly you were finding state police forces facing off against, these criminal gangs who were now incredibly armed. They're wielding sawed-off shotguns, Tommy guns, submachine guns, and the policemen are having to combat this with 38 pistols. And so the National Firearms Act was passed, and it imposed a new set of restrictions. It started to limit barrel sizes, firing rates, all sorts of things. And so while the regulation of, let's say, Tommy guns, these kind of submachine guns were not that controversial in terms of the Second Amendment. What was, though, is things like sawed-off shotguns. Because while a machine gun is a military kind of grade weapon, a sawed-off shotgun is not, right? The military doesn't issue sawed-off shotguns as part of kind of their regular arsenal. Like, yes, you can find examples perhaps where, some kind of special forces unit or some small unit at some point in time, used a sawed-off shotgun. And so the question is like, well, does one instance of the use of a weapon by the military suddenly put it under the power of the federal government to regulate, or not? And so, given though that sawed-off shotguns were part of this regulation and yet not really part of military issue, there was a lawsuit. And it went to the Supreme Court, and the Supreme Court upheld the constitutionality of the National Firearms Act, which basically, once again, reaffirmed the federal government's power and to regulate some of these new weapons that previously they had not been able, to wield. And then over time, we saw some other regulations. For example, like in the post-Reagan assassination attempt era, we saw an attempt, we saw an assault weapons ban. But then we later saw a sunset on that. So in like 2004, that expired. And then we get to 2008, in which the District of Columbia, so Washington, D.C., had put a law which restricted the sale and ownership of handguns. And now, once again, like these handguns are certainly not military-grade weapons. And this is a greater imposition than other government entities had put into place, particularly because of interest, though, is that Washington, D.C. is a federal district. Now, if you recall, going back, the Second Amendment had yet to be incorporated, meaning it did not apply to the states. It protected you, perhaps from the federal government, and protected the states from the federal government. Essentially, like states could put whatever regulations that they wanted to. The question was, what regulations could the federal government impose? And the Supreme Court in 2008 ruled that Washington, D.C.'s handgun ban violated the Second Amendment. And then based upon that, 2 years later, the Supreme Court struck down Chicago's handgun ban. Thus, by overturning a state, or in this case, a city ordinance restricting the sale and ownership of a certain class of firearms, it is now applying under the Second Amendment, on the rationale of the Second Amendment. It is now incorporating the Second Amendment, meaning when we started, we asked that question of, does the Second Amendment apply to the states? Is it a state right? Or is it an individual right? Well, in 2010, the Supreme Court essentially answered that question. By incorporating the Second Amendment, it is stating that the Second Amendment is now an individual right. Because it means that now what restrictions states impose upon its citizens also have to follow the Second Amendment. So the Second Amendment protects you from the federal government, which it always had, and now it also protects you from the state government. Now, it doesn't fully answer the question of, well, okay, well, then what restrictions can, they place? I mean, there's still, a lot of gray. So for example, um, a, an AR-15, could either the state or the federal government, regulate, the sale and ownership of an AR-15, rifle? And the answer to that is not, going to fully clear. I mean, they have in the past. The Supreme Court has not overturned it. It's not said that you cannot. Furthermore, like, let's say if you can't ban the sale and ownership of handguns, like, well, what about ammunition? Can the state regulate ammunition in a way? Is ammunition different from that of firearms themselves? And so there's still a lot of questions. But in general, I mean, the Supreme Court, it kind of stayed out of Second Amendment issues. But recently, it's kind of, stepped into that fray, answered, some of the questions about the role of the Second Amendment as it pertains to individual rights. And so, again, that's McDonald versus City of Chicago is one of your foundational cases. There's an assignment, on it. But in general, like that case is a big case because it incorporates the Second Amendment. It applies it to the states using both the Due Process Clause of the 14th Amendment and the Second Amendment. And so, as far as today, one of the things that we need to think about as far as policy is there's a difference between policy and the constitutionality of a policy. And sometimes they intersect and sometimes they don't. Meaning, you might be able to construct the greatest public policy to solve a certain issue. The question then becomes, whether or not that policy is constitutional or not. So some things that are really great in terms of public policies might actually be unconstitutional. Or some things that might be policies that might be really terrible might be constitutional. And so we've been focusing a lot on the constitutionality and really haven't focused a lot on the kind of public policy and the merits of the public policy itself. But that's going to kind of be something that we'll look at a little bit, at a later date, given that right now we're really focusing on the Bill of Rights and what the Bill of Rights means. We're focusing kind of solely within a constitutional realm, but just realize that in reality, that constitutional realm is not a bubble. It intersects with, the policy realm and the merits of policy and the efficacy of policy as well. All right, so that was the rest of the First Amendment and the Second Amendment. And then starting next week, we'll look at, search and seizure rights and start looking at kind of rights of citizens as, within trials as kind of in criminal cases and court cases. All right, we'll talk to you later. Hope you enjoyed this.